Chapter 2 State and Local Roles in the Child Support Enforcement Program. Introduction. Child support enforcement on the state and local levels specifically includes all activities devoted to securing the payment of established financial obligations from absent parents. To achieve this end, child support enforcement programs carry out many important federally mandated functions at the state and local levels. These functions require an investment of significant time and resources and range from establishing a case file to enforcing a support obligation. In addition, state and local agencies are responsible for locating absent parents, establishing paternity, establishing equitable support obligations, monitoring payments for compliance with orders, distributing collections, and safeguarding confidential information. The effective culmination of these efforts can minimize the use of court time, since absent parents are more likely to pay child support if their cases are processed properly and expeditiously. However, when cases go to court, attorneys and judges must rely on information gathered by the child support agency to protect the interests of both children and state. Conversely, the agency depends on the power of the courts to enforce child support obligations. To be effective, program attorneys must be familiar with the child support enforcement program as mandated by federal law and regulations, and the effect that the program has on the courts, children, and states, as well as taxpayers. The following is a discussion of how federal regulations affect the child support enforcement program. Title 4, Estate Plan Requirements. Generally, the State Welfare Agency administers the AFDC program, as well as other financial assistance programs. The state or local agency administering this program is commonly known as the 4 agency, since Title 4 of the Social Security Act set up the AFDC program to provide financial assistance to families with dependent children. The AFDC program and the Child Support Enforcement Program are administered by states or localities pursuant to federal guidelines. A review of some of the more relevant regulations will help explain the responsibilities related to child support of the 4 agency. To receive federal funds, the Welfare Agency and the Child Support Enforcement Agency each must have an approved state plan. A state plan is an agreement between the state and federal governments requiring the former to perform certain minimum duties in order to receive federal funds. Also, there are child support-related requirements imposed on the Welfare Agency by Congress through statute and by the Department of Health and Human Services, DHHS, through regulations. These regulations are intended to ensure that all procedures used and information obtained result in enforceable cases. The Welfare Agency must gather information as part of determining the applicant's eligibility. An applicant's unwillingness to provide information can cause an immediate adverse effect on his or her financial assistance eligibility. An applicant must show good cause for not providing such information. Good cause is defined at 45 CFR 232.40 and is discussed below. An applicant/recipient for AFDC must meet 2 child support-related conditions: assignment of rights to child support and cooperation in obtaining child support. Assignment of rights to support is a condition of eligibility for assistance. The 4 agency must require each AFDC applicant or recipient to assign to the state all rights to past and present support from any other person. 42 U.S.C. 602(26). This assignment applies both to the applicant and to any other member of the family for whom assistance is being sought and to whom future payments will be made. The assignment includes arrearages due on the date the assignment becomes effective, in addition to current and future support. 45 CFR 232.11 and 45 CFR 302.50. If the relative with whom a child is living fails to comply with this requirement, that relative is denied eligibility without regard to other eligibility factors. If the relative with whom a child is living is found to be ineligible for assistance because of failure to comply with the requirements of this section, any aid for which such child is eligible will be provided in the form of protective payments. Protective payments are made to a third person to spend on behalf of the eligible child or children. An assignment by operation of state law may be used in lieu of the assignment described above. If there is a failure to execute an assignment, the state still may attempt to establish paternity and collect child support pursuant to appropriate state statutes and regulations. Cooperation in obtaining support. The Title IV estate plan must meet, inter alia, all of the following requirements. The plan must provide that, as a condition of eligibility for assistance, each applicant for or recipient of AFDC will be required to cooperate, unless good cause for refusing to do so is determined to exist, with the state in identifying and locating the parent of a child for whom aid is claimed, establishing the paternity of a child born out of wedlock for whom aid is claimed, obtaining support payments for the applicant or recipient and for a child for whom aid is claimed, obtaining any other payments or property due the applicant or recipient or the child. The estate plan must specify that cooperation includes any of the following actions that are relevant to, or necessary for, the achievement of the objectives specified above. Appearing at an office of the state or local 4A or 4D agency as necessary to provide verbal or written information, or documentary evidence, known to, possessed by, or reasonably obtainable by the applicant or recipient. Appearing as a witness at judicial or other hearings or proceedings, providing information or attesting to the lack of information under penalty of perjury, forwarding to the child support agency any child support payments received from the absent parent after an assignment has been made. The estate plan must provide that, if the child support agency notifies the state or local 4 agency of evidence of failure to cooperate, the state or local agency will act upon that information to enforce these eligibility requirements. The estate plan must provide that if the custodial relative fails to cooperate as required by 45 CFR 232.12, the state or local agency will deny assistance to the custodial relative without regard to other eligibility factors. Provide assistance to the eligible child in the form of protective payments. Such assistance will be determined without regard to the needs of the custodial relative. The estate plan must provide an applicant for or recipient of AFDC with an opportunity to claim good cause for refusing to cooperate. The state or local agency must notify such person, in writing, of the right to claim good cause as an exception to the cooperation requirement. The notice must advise the applicant or recipient of the potential benefits the child may derive from establishing paternity and securing support. Advise the applicant or recipient that, by law, cooperation in establishing paternity and securing support is a condition of eligibility for AFDC. Advise the applicant or recipient that if the state or local agency determines that there is good cause, the applicant or recipient will be excused from the cooperation requirement. The applicant or recipient must provide corroborative evidence of a good cause circumstance and, when requested, must furnish sufficient information to permit the state or local agency to investigate the circumstances. The state or local agency must provide, on request, reasonable assistance in obtaining the corroborative evidence, on the basis of the evidence supplied in the agency's investigation. If necessary, the state or local 4 agency will determine whether cooperation would be against the best interests of the child. Generally, the state 4D agency will not attempt to establish paternity and collect support in those cases where the applicant or recipient is determined to have good cause for refusing to cooperate. However, the state 4D agency may attempt to establish paternity and collect support in those cases where the 4 agency determines that this can be done without risk to the applicant or recipient if done without his or her participation. The 4 agency's final determination that good cause does or does not exist will be in writing, contain the agency's findings and basis for determination, and be entered into the AFDC case record. If the 4 agency determines that good cause does not exist, the applicant or recipient will be so notified and afforded an opportunity to cooperate, withdraw the application for assistance, or have the case closed. Continued refusal to cooperate will result in the applicant's ineligibility for AFDC. The children involved will still be eligible for AFDC for their own needs. However, the children's grant will go to another person in the form of protective payments. Circumstances under which cooperation may be against the best interests of the child are Physical or emotional harm to the child for whom support is to be sought. Physical or emotional harm to the parent or custodial relative with whom the child is living of such nature or degree that it reduces such person's capacity to care for the child adequately. The child for whom support is sought was conceived as a result of incest or forcible rape. Legal proceedings for the adoption are pending before a court of competent jurisdiction. The applicant or recipient currently is being assisted by a public or a licensed private social agency to resolve the issue of whether to keep the child or relinquish him or her for adoption, and discussions have not gone on for more than 3 months. Title 4D Plan Requirements and Operations Standards. The state plan requirements and standards for program operations for 4D agencies are found in 45 CFR 302 and 303. This section discusses mandatory caseload characteristics and the functional steps the 4D agency takes as a case is processed. Since the inception of the Child Support Enforcement Program in 1975, states and local agencies have been required to provide equal services to both welfare and non-welfare families. In 1984, Congress re-emphasized this responsibility by revising Section 451 of the Social Security Act, 42 U.S.C. 651, to require specifically that assistance in obtaining support will be made available under this part to all children, whether or not eligible for aid under Part A, for whom such assistance is requested. In addition, Congress reinstated the state's responsibility to establish paternity and secure support for children in foster care who are receiving federal assistance through Title IV of the Social Security Act. In 1980, Congress transferred the AFDC foster care program from Title IV of the Act to the newly created Title IV because the foster care program was no longer funded or administered under Title IV. The provision for assignment of support rights by AFDC recipients required by 42 U.S.C. 602-26, no longer applied to foster care cases. This meant that Title IV child support enforcement services were not available for Title IV foster care cases except as non-AFDC cases. To receive 4D services as a non-AFDC case, the child's parent, legal guardian, or the entity given custody of the foster child by the courts had to apply to the 4D agency pursuant to 42 U.S.C. 654-6. To remedy this situation, Congress added 42 U.S.C. 671-17, to require states to secure an assignment of support rights on behalf of children receiving foster care maintenance payments under Title IV, and amended 42 U.S.C. 654-4B. 656A, 657D, and 664A, to require 4D agencies to collect and distribute child support for 4E foster care maintenance cases. Processing a child support case. The steps a child support case goes through before it shows up in court are both numerous and complex. This section provides an overview of this preparation process. The specific tasks include eligibility determination, intake, locate, paternity establishment, support order establishment, monitoring, and enforcement. Exhibit 2.1 depicts the flow of cases through the separate functions. Eligibility determination. New cases originate in one of 3 ways: 1. Referral from the public assistance or foster care agency, 2. Application from a non-public assistance recipient, and 3. Referral from another state. The 4A or 4E agency determines whether a public assistance applicant is eligible for AFDC or foster care. If the applicant is determined eligible, and there is a duty to pay child support by an absent parent, the case must be referred to the Child Support Enforcement Agency. The referral must contain an assignment of support rights and an agreement to cooperate, in addition to other pertinent information discussed below under intake. The assignment of support rights, completed by the applicant as a condition of eligibility, constitutes an obligation owed the state by the individual responsible for providing support. This obligation must be legally binding and, thus, must be established through an order of a court of competent jurisdiction or by other legal processes established by state law. Failure to execute such an assignment results in a denial of eligibility for assistance to the applicant, and any assistance to which dependent children are entitled must be made in the form of protective payments. The state plan must provide that the same level of support enforcement services be provided to individuals not receiving public assistance that are provided to AFDC or foster care recipients. Such individuals, often referred to as non-AFDC clients, must file an application with the State 4D agency or with other state or local offices the State 4D agency has authorized to accept non-AFDC applications on its behalf. Under PL 98-378, the state must charge an application fee, not to exceed $25. 45 CFR 302.33 allows the state the option of charging the fee to the applicant or paying the fee out of state funds. Either way, the state may seek to recover the fee from the absent parent in order to repay the applicant or itself. 45 CFR 302.30 requires that states publicize the availability of child support enforcement services, including any application fees that may be imposed for non-AFDC. Interstate cases may be referred by other states using several procedures. The state where the family resides may request the state where the absent parent resides or works to withhold his or her income in order to enforce an in-state or out-of-state support order. The initiating state may request the responding state to establish and/or enforce an obligation through use of the Uniform Reciprocal Enforcement of Support Act, URASA. If an order exists in the absent parent's jurisdiction, the initiating state may simply request the absent parent's jurisdiction to enforce it using available remedies. Intake. Once the Child Support Enforcement Agency receives the appropriate forms from the welfare agency, the non-AFDC applicant, or another state, a case record must be established. The information needed to open a child support case includes information on the custodial family, information on the absent parent, and executed assignment of support rights or non-AFDC application. The intake function consists of compiling the data received from the above sources along with other information available to the Child Support Enforcement Agency. Some states have designed and implemented automated computer interfaces to augment the information available to the child support enforcement worker during the intake process. Preparation of an accurate and complete case record is very important to the child support enforcement process. Later action on the case often depends on information collected at this point in the case processing sequence. In addition, a well-prepared case minimizes the use of judicial time, establishes a verifiable audit trail, and generally helps the system operate effectively. Locate. During case preparation, the child support enforcement worker will try to verify an address for the absent parent. If the worker cannot verify an address, federal law requires that the Child Support Enforcement Agency attempt to locate the absent parent. If necessary, these locate efforts must extend across state lines, and the out-of-state agency must assist in the effort. There are 3 levels of location efforts: local, state, and federal. Except for requests from other states, location efforts begin at the local Child Support Enforcement Office. The request for locate services may be made by a court with jurisdiction to issue child support orders, the caretaker parent or agent of a child not receiving public assistance, or the agency seeking to collect child support payment. Local locate efforts involve all community sources of information on the absent parent. The best local source is the custodial relative. If the custodial relative is an AFDC recipient, he or she must cooperate and reveal this information as a condition of AFDC eligibility. 87. To contact these sources, the Child Support Enforcement Agency must establish a working relationship with all appropriate local resources. Some of these sources may be reluctant to cooperate because of the Privacy Act. To encourage the source to reveal the information, the Child Support Enforcement worker or attorney should explain the purpose of the 4D program and its confidentiality requirement for safeguarding information. Also, many state statutes require that this information be provided to the 4D agency. Portions of the Child Support Enforcement Amendments of 1984 contain such requirements, applicable to private entities such as employers. The state also must have a State Parent Locator Service, SPLS, to contact State 9. agencies that may have information concerning the location of the absent parent. The SPLS should have contacts with all appropriate state agencies, but at least contact with those agencies that maintain records concerning public assistance and social services, driver's licenses and vehicle registration, employment, revenue, law enforcement. To check these records, the SPLS generally must have the absent parent's social security number and his or her date and place of birth. Also, the SPLS acts as a clearinghouse for interstate locate efforts. The SPLS submits and receives requests to locate an absent parent who is residing in a state other than the one where the child and caretaker parent reside. Under a federal requirement of cooperation, the SPLS receiving such a request must take steps to locate the absent parent and notify the state that initiated the request concerning the search results. Federal locate efforts are discussed in Chapter 1. Paternity establishment. Paternity establishment is very important to the child support enforcement program. Of the children born out of wedlock who live and are not adopted, approximately 60% receive welfare. This results in a high expenditure of AFDC, the taxpayer's burden. In addition, national demographic trends demand that child support enforcement programs place high priority on establishing paternity. How a paternity case is initiated depends on whether or not the mother is receiving AFDC. Although a woman who is not a recipient of AFDC is under no legal obligation to establish the paternity of her child, she can apply to the Child Support Enforcement Agency for use of its services in attempting to establish paternity. According to the Child Support Enforcement Amendments of 1984, the 4D agency may charge an application fee of not more than $25 for these services in non-AFDC cases. On the other hand, AFDC and foster care recipients are required by law to cooperate in locating and identifying the parent of the child for whom aid is requested or to establish good cause for refusing to do so. Assessment. Establishment. If no existing court order determines the amount of the support obligation in a case, the state must make a financial assessment of the amount of the obligation under a formula or guideline developed by the agency. This financial assessment is used to recommend an amount of legal obligation pursuant to a consent agreement or an administrative determination. The court also may use the assessment as a guide when setting the amount of the obligation in the court order. Under 45 CFR 302.56. The Child Support Enforcement Agency must establish specific and numeric guidelines, by law or judicial or administrative action, for setting child support award amounts within the state. By October 1, 1987, these guidelines must be made available to all persons in the state whose duty it is to set child support award amounts, but the guidelines need not be binding. The assessment generally is conducted through contacts with the absent parent, when the individual will cooperate, the caretaker parent, the current or past employer, credit agencies, banks and other lending institutions, and insurance companies. Investigation serves several useful functions. It forms the basis of an administrative order or stipulation setting the amount of a legal obligation. Many 4D agencies attempt to negotiate consent orders with the responsible parent prior to referring cases for legal action. Finally, if a consent agreement is not reached, the investigation can provide program attorneys with valuable information to use in fashioning a recommended amount, which the court may consider entering in the support order. Sometimes an order of support can be established with the cooperation of the absent parent, other times a court or administrative hearing is necessary. If the parent must be summoned to court and does not appear, the order may be established by default. Under the Child Support Enforcement Amendments of 1984, all newly established or modified support orders must include a mandatory wage withholding provision as an automatic and preferred enforcement technique should the absent parent become delinquent in paying child support. Monitoring/enforcement. Accurate monitoring of child support payments is essential to the enforcement of the obligation, especially since it can help prevent the accumulation of arrearages. Under the state plan, the 4D agency must maintain an effective system for identifying, within 30 days, those cases in which there is a failure to comply with the established support obligation, and contact delinquent individuals as soon as possible in order to enforce the obligation and obtain the current support amount plus any arrearages. Pursuant to 45 CFR 302.75, the 4D agency may impose a late payment charge of not less than 3% or more than 6% of overdue support. The mandatory wage withholding procedures required by the Child Support Enforcement Amendments of 1984 will have a major impact on agency enforcement tactics. Under the new law, all new or modified support orders must contain a provision for withholding wages as a means of collecting child support. Withholding will go into effect without the need for any amendment to the support order involved or any further action by the court or administrative agency once the arrearage equals 30 days support. Mandatory wage withholding is discussed in detail in Chapter 8. And interstate wage withholding is discussed in detail in Chapter 10. Even without a wage withholding provision, the Child Support Enforcement Agency should attempt to secure voluntary compliance before relying on administrative or judicial enforcement. These initial non-judicial enforcement techniques can minimize the use of court personnel and attorneys. If the non-judicial enforcement techniques are unsuccessful, the Child Support Enforcement Agency must be ready to use its or a court's authority quickly to enforce the obligation and establish regular payments. Numerous methods can be employed to encourage delinquent absent parents to comply with their financial obligations. These methods include but are not limited to interviews, personal contacts, telephone collection calls, billing systems and delinquency notices. A Child Support Enforcement Agency bases its selection of a particular technique on a consideration of case characteristics, such as past payment history, age of the established obligation, dates since the last payment was received, location, income, and resources available to the absent parent. Attempts to collect support must include the following procedures as applicable and necessary. Automatic mandatory wage withholding pursuant to 45 CFR 303.100. Withholding of unemployment compensation benefits pursuant to 45 CFR 302.65. Contempt proceedings to enforce an existing court order where it can be shown that the support obliger had the ability to pay support but refused to do so. Interception of state and federal income tax refunds pursuant to 45 CFR 303.102 and 45 CFR 303.72. Garnishment or similar proceedings if the state's statutes permit such a procedure and if the individual can be brought under the jurisdiction of the court. Proceedings to establish liens on real and personal property pursuant to 45 CFR 303.103. Where appropriate. Proceedings to attach real or personal property if the state's law provides for such a procedure and the individual is subject to such procedure. Proceedings to require an obligor to post security or a bond or give some other guarantee to secure payment pursuant to 45 CFR 303.104, where appropriate. Proceedings to secure and enforce medical support obligations pursuant to 45 CFR 306.51. Reports to consumer reporting agencies regarding an obligor's overdue support, pursuant to 45 CFR 303.105. Applications to use the federal courts of the United States and proceedings to enforce an order in the federal courts of the United States if such application is certified pursuant to 45 CFR 303.73. Application for collection of the delinquent child support obligation by the Secretary of the Treasury - for any other collection or enforcement procedure described in the state plan. Maintaining case records. In addition to carrying out the above activities, federal regulations require the state or local 4D agency, including subcontracting agencies, to keep careful records. The elements of a complete case record include, pursuant to 45 CFR 303.2, the following: the referral documents received from the 4 agency or the application for 4D services by another individual. Records of any contacts with 1. An applicant or recipient of assistance under Title IV, who is required to cooperate, 2. An individual who has applied for service, and 3. The absent parent and the date, reason, and result of these contacts. records of efforts to use local, state, and federal locate resources and the dates and results of these efforts. Records of any information collected on medical support as listed in 45 CFR 306.50. A. Records identifying the court order or, if there is no court order, the calculation of the amount of the obligation using the formula prescribed in the state plan. Records of any actions taken as outlined in 45 CFR 303.3 through 303.6, including the dates and results thereof. Records of communications to and from the state or local agency administering the state's Title IV, a plan, the Oaks Regional Office, and any other 4D agencies. Notation in the case record of the closing of the case, including the date thereof and the reason for taking the action. An agency that prepares cases accurately and takes timely enforcement measures can reduce court backlogs. Rapid enforcement of child support obligations conditions the absent parent to avoid the inconvenience of court appearances by making regular child support payments. Distributing collections. In AFDC cases, the recipients must assign to the state any rights they have to support from any other person in their own behalf or in behalf of any other family member for whom assistance is being paid. The assignment includes all rights which have accrued at the time the assignment is made, including all arrearages due and collectible on that date. As a result of these assignments, 4D agencies become possessed of support collections each month which are attributable to AFDC cases and which must be distributed according to federal regulations. The distribution process is described below. In non-AFDC cases, there is no requirement that the support obligee assign his or her support rights to the state. Nevertheless, many states have found that it greatly increases the quality of their record keeping and the efficiency of their case processing procedures to require absent parents to make their support payments to the 4D agency, or to the court which entered the support order. Such a requirement may be imposed by statute, by judicial rule, or by way of a voluntary assignment of support rights for the purpose of collection. In these states, the 4D agency or the court must pass the support collection through to the family in a timely fashion. 45 CFR 302.57 sets forth requirements with which a state must comply in order to set up a payment processing system for non-AFDC cases. The state may charge the requesting parent a fee, not to exceed $25 annually and not to exceed state costs. Distribution of collections in AFDC cases for which there is an assignment under Section 471(17) of the Act is covered by 42 U.S.C. 657 and 45 CFR 302.51. Under these provisions, the first $50 collected that represents payment on current support due in a given month is forwarded to the family pursuant to 42 U.S.C. 657. 1. Amounts in excess of the first $50 of current support are retained by the state to reimburse itself for the AFDC paid to the family for the month in question. Any remaining amount of current support collected is paid to the family. If the amount collected exceeds the current support obligation, the state retains such amounts to reimburse itself for AFDC paid to the family for any sequence of months for which it has not yet been reimbursed. Once it has been reimbursed in full, the state distributes the remainder of the collection to the family. Also, the family's eligibility for public assistance will be redetermined by the 4D agency pursuant to 45 CFR 232.20. The $50 pass-through, which only applies to current support, then does not apply when the collection remedy is federal or state tax refund offsets. The distribution sequence in foster care cases follows a slightly different pattern. The foster care agency stands in for the family. 45 CFR 302.52 requires that payments that normally would be forwarded to the family be paid to the state agency responsible for supervising the child's placement and care. That agency may set aside such amounts for the child's future or may call or a part of the money available to the child's caretaker for meeting the child's daily needs. Safeguarding information. Safeguarding information is an extremely sensitive area because U.S. citizens have a right to privacy. Privacy is a unique interest primarily for what it is not. Privacy is not an economic or even a tangible interest. It is not among the necessities of life. It does not necessarily guarantee the right to engage in or refrain from any particular activity. Rather, privacy is a conceptual interest arising from an expectation of how government will ensure that an individual may hold himself free from public scrutiny if he so chooses. The freedom from unwarranted publicity is said to exist only so far as its assertion is consistent with law or public policy. Privacy is akin to the expectation interest of equality. Individuals expect government to treat those governed equally or to leave them alone altogether. The privacy right is not an explicit guarantee of the Constitution but is a contextual right that emanates from the First, Fourth, Fifth, and Ninth Amendments. Neither privacy nor equality can be viewed as independent rights or interests, but rather each rises to the level of constitutional significance only within certain factual contexts. Privacy requires a wholly qualitative assessment of the interests affected by the governmental intrusion, with a relatively undefined balancing of interests as the vehicle for arriving at a result. To be constitutionally protected, privacy must be considered a fundamental right. In fact, few aspects of an individual's life are considered essential, and therefore, protected from government intrusion, regulation, or prohibition. Interests such as speech, thought, sex, education, and family, however, have been consistently set apart as meriting special consideration. Courts have held that these interests are so fundamental that they are likely to continue being the basic concerns of human society even though times and other customs change. The constitutional right to privacy should be distinguished from the confidentiality and safeguarding of information requirements of the Social Security Act. The Social Security confidentiality requirements are sometimes thought of as the protection of rights to privacy. There is no constitutional safeguard of absolute privacy in child support cases. In fact, the opposite may be true. The taxpayers have a basic right to know where their dollars are going. In the early stages of the public assistance program, many wanted lists of welfare recipients to be published. Unfortunately, little consideration was given to the children who could suffer when the custodial parent would not accept public assistance because of the potential public scorn. Times changed, and so did attitudes. It was determined that the public interest in providing for children was more important than the public's right to know who applied for welfare. The reasoning was that people are poor through no fault of their own and, contrary to their own desires, must rely on public aid. Because they are honorable people for the most part, they should not be exposed to public ridicule. The children at any rate are innocent bystanders who should be protected. This is not a protection of a basic right of privacy, but is rather a specialized confidentiality requirement adopted for the good of the children in these specific cases. If the requirements are not followed, a state program may be found to be out of compliance and sanctions applied. Section 402(9) of the Social Security Act, Public Law 93-647, requires state plans to provide safeguards which permit the use or disclosure of information concerning applicants or recipients only to a. public officials who require such information in connection with their official duties or b. other persons for purposes directly connected with the administration of aid to families with dependent children. As described in 45 CFR 303.21, the Child Support Enforcement Agency must establish criteria, in accordance with state statutes, which impose legal sanctions on the misuse or improper disclosure of information concerning applicants or recipients of child support enforcement services. In addition to child support-related activities, case information may be used for the following activities: any investigations, prosecution, criminal, or civil proceeding conducted in connection with the administration of any such plan or program approved under Part A, B, C, or D of Title IV, under Titles 2, X, 14, 16, 19, or 20, or under the Supplemental Security Income Program of Title 16. The administration of any other federal or federally assisted program that provides assistance, in cash or in kind, or services directly to individuals on the basis of need. These safeguards shall specifically prohibit disclosure to any committee or legislative body, federal, state, or local, of any information that identifies by name or address any such applicant or recipient of public assistance, the Child Support Enforcement Program and the state court system. The ultimate goal of the Child Support Enforcement Program is to ensure that the responsibility for supporting children rests with the responsible parents, and, thereby, to diminish the demand for tax dollars. To meet this goal, state and local agencies must adhere to stringent legal requirements. Given these requirements, child support enforcement agencies invest significant time and resources to enforce the payment of child support by the responsible absent parent. In some cases, the child support agency's activities result in an admission by the absent parent that he or she is responsible for paying child support, saving valuable judicial time. However, some cases require litigation. In these instances, the effectiveness of the Child Support Enforcement Agency's efforts depend on fair and equitable action by the court. Child support enforcement attorneys and other program personnel have the responsibility to educate judges and other court personnel who must back the program's efforts with appropriate judicial remedies. The remainder of this handbook is devoted to describing that responsibility and identifying relevant substantive and procedural considerations.